Good afternoon, everyone. Thank you for joining this webinar on the subject of remote final hearings and remote fact-finding hearings. I am Cordelia Williams from Hunt Court Chambers in London. I'm a family law barrister specialising in private children and financial remedies work. And I have the great pleasure of speaking alongside Penny Howe QC, also from Hunt Court. Penny is a family law silk specialising in all aspects of children proceedings. And Penny's expertise is particularly helpful as she appeared in Re P, one of the leading cases on today's topic. A week is said to be a long time in politics, and at the moment it seems an even longer time in family law. Remote working has become the default overnight, and every week it feels like there's new guidance. The challenge for us family lawyers then is not whether to move with this trend, but how quickly and how competently we can keep up with all the changes. So I hope that today will help with that. I hope that you've received the handout that we've prepared. It's been sent in the chat function of this Zoom call. Hopefully you've received it that way. It's also been sent by email from Clerk Sean Collum. So if not received from the chat, hopefully by email. As this is a live webinar, please do keep your video and microphone switched off, but do use the chat function for any questions, and I'll look at that a few times during the webinar to keep track of any questions that have come up. Afterwards, do feel free to email us with any questions. My email and Penny's email address are set out at the end of the handout for any emails afterwards. So, Penny, would you please begin with the latest document from the President, the road ahead?
I will indeed. Thank you very much, Cordelia. Hello, everyone, and thanks so much for joining us. We thought we'd start with the document that was wittily entitled by the President, The Road Ahead. Now, this is a document that he produced on the 10th of June, so it's pretty up to date. It certainly postdates the official guidance by some way, and it really is a pretty comprehensive overview of where we've got to since the beginning of the pandemic. And there are some features in it which are of particular value to us in our consideration of the particular topic we have in hand. Much of the wisdom you can find in the part of the document in which the President addresses case management. And I really do commend to you that you have a look at page 11, starting at paragraph 44, and take on board all that the President has collected together in this part of the document, because you'll find that he produces a checklist which is immensely handy for everyone who's considering how to go about a remote hearing, and which triggers the advocates to think about how best to make it work. And those considerations are all about case management. They're also about the hearing format and how to optimise fairness for litigants, particularly who may be at a disadvantage in using remote technology. So that, I think, is a key aspect of it. The background to the document, though, is worth considering. The President's really clear now that, in contrast to how things were perceived to be likely to pan out at the beginning of the pandemic, we all know, because we're living it in our real lives, that we are stuck with this for some period of time to come. Although there's some chat now about distancing being of a 1 metre limit rather than a 2 metre limit, nonetheless, even at that level, there's going to continue to be a really severe impact on court facilities and on the way in which we would normally engage in hearings. And the President thinks that this is going to be the situation until at least the end of this year, quite possibly into 2021. And what's interesting is that although we'll look at how we got here in the case law that we will shortly discuss, the point the President makes is that one can no longer expect to adjourn a case to await a face-to-face hearing. It's unlikely to be an option. It might be for a very few cases, but certainly not for most. And in considering how to manage a hearing remotely, it's very much the case, and the Court of Appeal has emphasised that it is a case management decision of an ordinary variety to which the overriding objective applies with its checklist, and that that's the basis on which a judge will make his or her decision about how to proceed. It'll be no more amenable to appeal than any other case management decision. So the flurry of cases we've had going to the Court of Appeal, I suspect, may be slowing down to a trickle or even to an end. Really, really important, I think, to gather from this document also is that the message is loud and clear. Parties will not, according to the President, be able to litigate all the issues they choose or present extensive evidence or oral submissions. Now, I think this just reflects the panic in the ranks about the backlog we've now got. It's a huge tail of hearings. We all know about that long tail that will have to work its way through the system. I, for one, I'm already experiencing judges eyeballing me down the camera and questioning me rigorously at CMH stage as to why I think a case will take a particular length of time. And after my justification has been offered, such as it is, being told I can have half that time. The judges are going to be incredibly tough with us. We're going to have to be really rigorous about identifying our issues and identifying the evidence that needs to be called and heard to make those issues before the court. So that, I think, was pretty much the takeaway message for me, alongside, as I say, the practical part of the document that I focused on, which is really the case management checklist. It's like a one-stop shop for all you need to think about in order to set up an appropriate remote or hybrid hearing. And just to mention also that the President suggests we all have regard to part 6 of the recent Family Justice Observatory research paper, in which it too sets out some considerations for remote hearings. And I'll come back to some of those points later in our talk when we discuss practical tips for how to manage things in the best way that we can. So now, Cordelia will take this on further with a look at the guidance, given that this document from the President is emphatically not guidance. We'll now have a think about what guidance there is.
Thank you, Penny. So for everyone, I'm looking now at page 1 of the handout that has been sent again on the chat function. So the chat sidebar at the bottom of the Zoom, hopefully you'll be able to see that. I'm looking at paragraph 2, because Penny's dealt with paragraph 1, the road ahead. So now looking at paragraph 2 of the private and public children guidance. This was Mr. Justice MacDonald's document on the 16th of April. The 16th of April being the update of the original version, the 4th update. It does stress that the remote family court must not preclude the possibility of an in-person attended hearing where this can be achieved safely. I think that's probably the first point to mention, dovetailing on from Penny's presentation of the road ahead. It seems that that's likely to be increasingly common in future. We've had the initial lockdown stage where everything it feels like is remote, and now it's more likely to be moving on to hybrid and in person. And this document, although we expect it will be updated soon, because 16th of April now frankly feels stale, nevertheless seems to pave the way for that to start to happen. So the things that are important from the update were firstly made very clear that the decision of whether or not to proceed with a remote hearing or to adjourn proceedings is a judicial decision. That was underlined before it, but this is the guidance document that first made that exceptionally clear. It advises particular caution where the parties don't consent to a remote hearing, albeit when they do agree it should go ahead as a remote hearing. That is not a green light to the judge to conduct a remote hearing. There does need to still be judicial oversight of how appropriate the case is to be heard remotely. The update is helpful in that it sets out the cases likely to be appropriate for remote hearing, the word likely being stressed because this is, of course, a judicial decision in bold and underlined. But the cases that are likely to be appropriate for remote hearing: 1, the case management hearings, or hearings heard on basis of submissions only. 2, a final hearing on submissions only and no evidence, no oral evidence. 3, a public law final hearing where the care plan is opposed, but the only witnesses to be called are the social worker and the guardian. And 4thly, where only the expert medical witnesses are to be called to give evidence. So if your case falls into one of those brackets, use this guidance to argue, if it suits you, of course, that your case is likely to be appropriate for remote hearing. The cases that this guidance say are unlikely to be appropriate for remote hearing are those where parents or other lay witnesses are to give evidence. And that's for obvious reasons that will become apparent when we get to our useful tips section at the end, that lay witnesses and parents in cases struggle more with the technology than professionals do. The update, the McDonald's update 16th of April did include the following new information. First of all, it was the prioritisation of family business. So it sets out a rather terrifying categorisation of work that must be done versus work that should be done, and work that the court will endeavour to do as bottom of the pile. There's no great surprises what features in the work that must be done. It's predominantly care work, EPOs, emergency protection orders, interim care orders, and also urgent applications in private law children cases. Of course, can be very urgent matters in those. Domestic abuse injunctions, we've all seen the horrendous statistics of the increases in domestic abuse in lockdown, and so that features on the list. Urgent applications in financial remedy cases does appear on the list. I suppose, but I don't suppose I see in the finance documents that I'll address you on later on in the webinar. Things such as freezing applications, etc., appear, but quite notably, they're at the bottom of even the work that must be done list. So it does rather feel that finance needs to take a backseat quite properly for public law proceedings in at least the short term. It includes wellbeing advice and links to further resources. Again, we'll come on to that more when we address the useful tips at the end. It introduces the cloud video platform, the CVP, we all now know it as, the MOJ-wide contract for video conferencing. The great news for us is that the usage costs are borne by the court and that it can be accessed from any video and audio capable device with internet. So it, on the face of it, is going to be much easier than before every hearing saying who's doing the hearing, is it Zoom, is it life size, is it Teams? Hopefully we'll have less of that the more that CVP is adopted and used by the courts. In terms of the next sort of guidance, I say guidance because it is very clearly, like the Roadhead document, not official guidance. And I'm now looking at paragraph 3 of the handout, the communication on the 9th of April from Lord Chief Justice, Master of the Rolls and the President of the Family Division. It sets out the indicators to assist judges deciding whether a hearing should be conducted remotely, but they've been adopted in Miss Justice McDonald's guidance document that I've just addressed you on, and indeed it repeats most of what I've just said. So I'm not going to address it again now. And by virtue of the date and the fact it's already been mostly incorporated in guidance, it's rather been overtaken. We're now going to move on to the timeline of the roller coaster that the last few weeks and months have been, and I'm going to start us off and then Penny will continue when we get to the EP. So I'm now at paragraph 4. I'm going to start us off with Re EK decision. The judgment was released on the 2nd of April, and Mr. Justice Mostyn was almost, I hesitate to use the phrase showing off, but he was very pleased with the fact that the hearing had gone so well via Skype. So it was a very useful judgment to have as an example for perhaps judges who are more cautious that this is a platform that can be used, and actually remote hearings, even when they're complicated and lengthy, can be successful. It is a contested care hearing, and as you can see by the date, it was conducted not long after the Prime Minister's lockdown announcement. We all remember that was the 23rd of March, and this judgment was released on the 22nd of April. Oral evidence was heard from 5 witnesses, including the parents, the children's guardian, a social worker, and an ISW. Interestingly, the father gave evidence assisted by an intermediary. But reading the judgment, there were no comments in the judgment about this being more difficult because it was a remote hearing. The intermediary comment seems to have gone by in the judgment unremarked upon. So hopefully that means that there were no issues. And certainly intermediary is one of the factors we need to look at when considering time estimate of a remote final hearing. But hopefully it's one that can be accommodated as readily as it could be at an in-person hearing. Otherwise, it's a relatively unremarkable decision. So unless Penny, you have anything else that you wish me to address you on with Re-EK, I'm going to hand back over to Penny for Re-P, which was the first biggie.
Thank you. That's great. Thanks, Cordelia. I can see that there's some chat on the side about the CVP. We'll come back to that. I've had some experience with CVP, and it'll be useful to chat about that further down the line. But let's stick with the look at the case law. It's kind of informative in telling us how we got to where we are. And I did have the joy and the privilege of being in Re-P, but I have to immediately confess that I was brought into Re-P at the very last moment by my lovely colleague Labea Ramadan, and so I arrived in the door just as the case was about to go in front of the President for the hearing about which we'll now speak. This, as you probably already all know, was a factitious illness case which had been listed for a 15-day hearing. In fact, it was a rehearing because the first trial in October had collapsed. So already the child in question had experienced very, very significant delay. And so Judge Evans Gordon in Guildford was well up for a remote hearing, just in the teeth of the McDonald-J guidance, which had suggested that it was to be really business as usual, at least that's how it was read, and that we should all be cracking on remotely. The judge agreed, in fact, confirmed her decision that she would handle this case remotely. And in front of her, the mother's team agreed. In fact, there was just no issue about whether the hearing would proceed or not. And what I hear, although I can't confirm it to be true, is that in the general scrutinising of who was doing what in which court centre, it came to light that this 15-day hearing was to proceed, and that generated interest from the President, who effectively called it in to have a look at it himself. So we rocked up for the Guardian, hoping to persuade the court to continue on the good old-fashioned Guardian basis that delay would not do and would be harmful. Mother and her legal team, which now included Alison Munro, opposed the hearing proceeding. Everybody else wanted to crack on, although I would say the local authority were mindful, to be fair, about it. So we turned up with our arguments in hand. It took us 25 minutes to log on via Skype for Business for this hearing in front of the President. So any shred of optimism I had beforehand that we might persuade him to crack on for 15 days, or at least allow the judge to do so, had by the point we found ourselves in the hearing entirely receded. And indeed, that was just as well, because of course the President's view was that this was not a case that was amenable, and it shouldn't happen. So in his judgment, his focus was interesting. He didn't strike me as being all that familiar and comfortable with the remote technology. And he was very perplexed that a judge would find it disabling to come to a view of the evidence unless he or she could see the parties, the lay parties, and in this case, in particular, the mother, at all times, in response to witnesses, in interaction with her legal team. And it was the President's view that this was a major barrier to a hearing fairly proceeding, alongside many other issues that he identified as being potentially unsatisfactory. And whether another judge would have taken the same view about the value of fixing witnesses in your gaze is another question that perhaps we'll come on to. But of course, now, if we reflect where we might be on that argument 3 months down the line, as another judge said to me the other day in an FII case, which will proceed to a hybrid hearing, I will pin the witnesses on my screen, courtesy of the CVP. This was Mrs. Justice Knowles making it very, very clear that she will at all times have one eye fixed upon the parents on her screen, both pinned, so that she captures all that is to be seen of their demeanour and their responses to the evidence as it progresses. What does that tell us? I suppose it just backs up what the President has constantly tried to remind us, which is that we've all travelled an incredible road over the last 3 months. The things that worried us in March and April may well not be the things that worry us now. We have to keep abreast of the technology and how it's developing, and find workarounds so that we can progress cases to some kind of conclusion. We have to be so much less hesitant about that now. We move on from that to Ray A, which is also a leading judgment from the President, this time in the Court of Appeal on the 22nd of April. And I think even in the short space of time since Ray P, it had become obvious that there was fairly wide-scale panic in the ranks, and adjournments were happening left, right and centre. Every case in front of the family court appeared to be kicked down the road. And so in Ray A, the President was keen to point out this is perhaps the first solid iteration that this was a case management decision. It's individual to the facts of each case. You can't categorise cases to decide what is right and wrong for remote hearing. You have to look at the idiosyncratic features of each case. And in particular, I would suggest that in this authority, paragraph 3 is key, because there the Court of Appeal stressed what they called cardinal points that they felt were required to be stressed with the utmost emphasis, that being, as we've discussed, that this is a case management decision, and the fact that guidance is only temporary, and the fact that things are moving on a pace, and so one needs to be mindful of that. Don't get stuck on Ray P when there's a Ray A coming down the tracks. Factors to consider in determining whether a case is right to proceed remotely or should await an in-person hearing were laid out at paragraph 9. And there's quite a long list, which include, unsurprisingly, the importance and the nature of the issues to be determined, whether there's a special need for urgency. I find this one a really difficult one. There's always a need for urgency in care cases, and every children's case. There's always an argument that you're in a hurry, and how one can properly distinguish urgent from very urgent, I think, is something of a vexed question. Whether parties are legally represented, and I think really crucially, whether your lay parties can keep up with, engage in and follow what's going on remotely. This is, I think, the nub of it for me. Even clients who are notionally willing to undertake hearings remotely are often not very well equipped with technology, certainly not well equipped in the event they can't get the technology to work in the moment of the hearing. Whilst ideally all our witnesses would be equipped with laptops and tablets or a smartphone so that 2 lines of communication could be open at one time, I'm afraid in my experience that's a pretty rare beast in care proceedings, and I think that is a really important consideration. Again, there are some workarounds and fixes that we can come on to in due course. One of the factors, of course, to consider as to whether a remote hearing is suitable is the nature and degree to which evidence needs to be heard, how long the hearing is proposed to last, and again, notably the confidence of the court. How good is your judge at navigating remote technology? That, according to Ray A, is a factor in case management decision making. One can see how that might translate. If you're case managing in front of Mr. Justice Mostyn, you can anticipate exactly how your hearing will pan out. Less so in front of some of our other judges, although they too are having to come up to speed. And in Ray A, there was then a mention of the potential for hybrid hearings, as we now know them. What safe spaces could be used in the court estate for a mixed type of hearing to be convened. Again, Ray P had an echo of that, but this was more of a factor in Ray A that the Court of Appeal thought was important to consider. So I won't dwell on the facts because it's probably time-wise more sensible to move on to paragraph 8 of our handout and to talk about a decision by Mrs. Justice Evon in Local Authority and M and F. Now, this was, again, a potential 15-day fact-finding hearing, which had proceeded remotely by agreement to the extent that the expert witnesses and professional witnesses had been heard. And the crucial decision was whether a hearing should proceed to hear the evidence of the parents in the case and the grandmother in the case. Could that be done entirely remotely? Did it need to be done in hybrid fashion? And what was the right solution? And this was a really awful case in which a baby had died. The stakes couldn't have been higher. And so Mrs. Justice Evon gave the issue of the format of the hearing her most urgent and indeed really proper attention. And this is where I think we have a point of interest from the decision. You'll remember the factor in Ray P, the judge being very exercised, president being very exercised that judges must be able to see their witnesses. Well, in this one, Nick Goodwin QC, who is always up for an argument, advanced an argument to say, actually, the value of face-to-face evidence and of a judge witnessing a witness give evidence is overrated. And to support that argument, he called on a case in the civil jurisdiction, and indeed that in turn makes reference to a paper written by Mr. Justice Bingham, as he then was in 1985, which is really quite a compelling read, because it reminds us that in fact science and research would suggest that you can be wholly misled by a witness's demeanour. It is not the golden ticket to ascertaining the truth. And there are plenty of ways in which a hearing which has the party in front of you could result in you being misled. And so Nick Goodwin advanced the argument that that can't be the be-all and end-all of case management. It shouldn't be. And he also, in conjunction with one of the other advocates, advanced the argument, which may be useful in your armoury, that there are cases where witnesses may give better evidence if they're being dealt with remotely. For example, they may be less defensive, they may be less anxious, less nervous, are more inclined to tell the truth than otherwise. An analogy was drawn with vulnerable witnesses who we know participate remotely via video link in many of our cases, and we trust that that is a way to support them to give their best evidence. Why should that not be a factor in remote hearings that we conduct, where witnesses are not necessarily vulnerable, although likely very highly stressed? And Mrs. Justice Leven accepted that argument. She was persuaded that there would be cases where remote evidence from parents might actually be superior. And in this particular instance, having canvassed the option of a hybrid hearing, which would have required the mother to come to court, which she didn't want to do, would have required her to put a family member at risk. And having considered all the other relevant factors, Mrs. Justice Leven concluded that here was a really serious case, but one nonetheless where the remainder of the evidence was amenable to being heard remotely, and that is in fact what happened. So you contrast that decision with the outcome of Ray P, and you can see how case management allows the judge to be as flexible as possible and to take a view and to do so in a way that's beyond impeachment, provided they do so with regard to the various factors that one ought to take on board. So, having discussed Ray MF, we ought to move on. As always, time is going to be at a premium. And we come to Ray Q, and I think Cordelia is going to talk to you about that.
Thanks, Penny. So Ray Q was unusually decided by the President, even though it was an appeal of Deputy District Judge O'Leary's case management decision at the Central Family Board. And you can see why it was so important to be heard by the President when you read the judgment, because there was some perceived confusion that had arisen as a result of the Ray P decision, and the President thought it was necessary to become involved because of that. Also, because on a practical level, some case management in the case had already been done by the relevant DFJ at the CFC. So hierarchy-wise, the President thought that might be an appropriate factor. It was the first private law children appeal in relation to remote hearings. And it was an appeal against the refusal to proceed to a remote final hearing. The appeal was upheld as the welfare of the child demanded a hearing. It's factors that then can be used when we're arguing this one out in our cases. This was in the context of a very long-running private law dispute where the child had undoubtedly suffered significant emotional harm. And the child had a guardian, and the guardian was recommending a move away from mother's primary care. Mother had made sexual abuse allegations against father sexually abusing the child, and there'd been a fact-finding of that already, and there'd been no findings made. So that context is pretty critical when one's looking at the urgency for this 6.5-year-old child Q of moving, potentially that was going to be the decision of the court, from their current residence. Other than that, the judgment is largely fact-specific. It does reiterate that whether to hold a remote hearing is one for the judge, it's one individual to each case. We already know that by the date of this judgment, the 6th of May, from the guidance and from the preceding authorities. But nevertheless, it's helpful to underline it. I'm going to move on for the purposes of time and hand back to Penny for C.
Yes, thank you, Cordelia. I'm going to make this one quite brief. It's an interesting read. The bent of the judgment is much more about human rights than it is about practicalities. This was a case where Elizabeth Isaacs QC was unable to attend the final hearing of the mother's case. She was the lead for the mother. And so the appeal came on the basis that the court had nonetheless directed that the mother's evidence should proceed. And the nub of the question on appeal was whether that was fair to the mother. Did it breach her Article 6 rights? Was it reasonable to expect that her leading counsel should be somewhere else, whilst everyone else in the case was able to be present if they chose. And in a nutshell, the Court of Appeal said, absolutely, there is, of course, a right to a fair hearing, but it has to be balanced against all the other parties' rights to a fair hearing. It couldn't be a trump card to say that one's choice of advocate was incapable of being physically present, and the Court of Appeal was keen to say that one shouldn't undervalue cross-examination conducted remotely, and that it is, I think, in their view, if not of the same quality, it's not the same quality of experience, but it is capable of being managed perfectly effectively. That's a skill I think we're all going to need to practice, because there are some real differences between cross-examining in the court environment and doing so remotely. And I'll be interested to see if any of you are on the chat and want to offer your experiences of what that's been like for you, then please do. Later on, I'll share my own experience to date and offer you a little tip, if I can, as to how to make the best of it. So that is Ray C. We're now going to move to the section of this webinar which deals with financial remedies. That won't involve me at all, so I'll hand you back to Cordelia. And yes, I'll sit back and wait for the next section to join you again.
Thank you, Penny. Just to be clear, this section on financial remedies guidance, I'm going to rattle through it as quickly as I can, because we then come to perhaps the more interesting bit, which is our useful tips section. So any of you who don't practice in financial remedies, do hang on for that. Financial remedies guidance, I say I'm going to rattle through it because it's fairly easy to rattle through it. There's not a lot that is distinct from the children guidance. It's been quite clear, as I said at the beginning, that financial remedies has been deemed as a generalisation to be much less urgent work, and must step aside for judicial time to be spent on more urgent matters. I'm looking at paragraph 11 of the handout. This is the guidance that we do have in relation to financial remedies. We already touched on it at the beginning of the webinar in relation to children work, but there is a section on it in relation to financial remedies work. So I'm looking at the update of Mr. Justice MacDonald, again, 16th of April update. We haven't yet got an amendment. It helpfully endorses the document that His Honour Judge Hess and Mr. Justice Mostyn produced, dated 15th of April, sometime previously now, but when the update was when the MacDonald guidance was first produced, it was relatively recent. That sets out cases where it's likely or not likely that a hearing is appropriate to be heard remotely. So to carry on the list, but applying it specifically to financial remedies work, it's likely that case management hearings or hearings requiring submissions only can be properly conducted remotely. It's likely that a final hearing undertaken on submissions only with no evidence can be conducted remotely. So those are the two categories that are explicitly set out as likely to be appropriate by virtue of the MacDonald guidance. Financial remedy cases below High Court judge level are deemed in this document to be relatively short and straightforward generally. The majority, as we know in practice, tend to be needs cases, and majority tend not to involve a credibility assessment of the witnesses. Those are all factors, of course, that make it easier to have a remote hearing versus necessitating an in-person hearing. Even in the cases that do require the judge to make a credibility assessment, for example, where non-disclosure is alleged, MacDonald J assesses that the case is likely to be relatively short and relevant issues are likely to be able to be exposed and assessed by remote oral evidence. So I'll eagerly await some of the tips that Penny shares with us at the end for cross-examining remotely. Generally, the court should start from the position that a remote hearing is likely to be consistent with the interests of justice. I'm quoting now from the McDonald J document in relation to financial remedies. This will be especially so if the hearing will not involve oral evidence. However, even if it does, the court can safely assume that in many cases, a remote hearing will be appropriate. So the general point is, for financial remedies, you have an even stricter definition to necessitate an in-person hearing. And just our generalisation, quite apart from all the big money judgments that we read, it's going to be in 9 times out of 10 normal, inverted commas, cases, perfectly appropriate for there to be a remote financial remedies final hearing. An interesting point that was added specifically for financial remedies is that the court should be alive to the possibility that opposing a remote final hearing might arise from a motivation of husband or wife to delay the resolution of the case. And that's a point that I've had in a few cases already, that it's quite transparent that somebody's apparently huge protests about grave concerns about assessing credibility, when actually credibility is not an issue in a finance case, or not, as the case may be, actually arises because it suits them to remain in the FMH for longer, for example, or it suits them to have an even longer continuance of the status quo on maintenance, another example. So be alive that that has been explicitly raised in the McDonald guidance as something that judges need to be careful of. So include that in any documents when you're arguing that point. I'm now looking at paragraph 12, the communication with Justice Mostyn. Eons ago, it feels like, 17th of March, one of the first forays into the new future of remote working. I'm sure many of you, like me, remember receiving it and hastily downloading it, thinking this will be the beginning of a new era, not really sure where it was all going to go. So it's a very short document, but it was helpful. And it proposed that FDA should be done wherever possible using the accelerated paper-only procedure. It feels like I've recommended that procedure in a couple of my cases, and solicitors instructed me we've been working on a paper-only basis. But it was still a relatively rare feature of financial remedies work, I think it's fair to say. Most FDAs, even if they were relatively straightforward, ended up at an in-person FDA. Whereas now it seems that paper-only procedure for FDAs is all over the shop, and everyone's cottoned on to actually what a cost saver and how straightforward it is. So hopefully many of you are experiencing the same with your financial cases that are coming up for first appointment. The Mostyn communication explicitly says that private FDR should be encouraged. Again, this is following on many practitioners' recommendations. I don't know how many of you have had private FDRs go through successfully before and after lockdown. Of course, they have the great advantage of they're much easier to organise remotely on a day that's convenient to everyone, etc. Mostyn adds that the default for finance hearings is to be heard remotely. So made that very clear, and he was well ahead of the curve, 17th of March, made that clear a long time ago. Physical hearings should only take place where absolutely unavoidable, and the use of e-bundles should be mandatory. And we'll come on to mention that in a moment about e-bundling. Paragraph 13 was the guidance, it was on Judge O'Dwyer at the CFC, but actually, even though it's CFC specific, it's pretty helpful in setting out what the CFC's criteria were for urgent applications versus non-urgent hearings. It was said to be only for hearings listed until the 1st of May, so I'm conscious that this is now out of date. However, there hasn't been any update to it since, so unless or until we get an update, I think it's still useful to include. And I set out on the handout the hearings which are deemed to be urgent, from financial remedy hearings deemed to be urgent, and those non-urgent. So I'm not going to repeat them because they're on the handout. I've already touched on private FDRs. I also stress arbitration options. Arbitration can be a really useful function in finance cases. I stress that a lot of instructing solicitors, when they approach me to discuss whether or not we should use arbitration as an option, are worried about the cost, but they really can be very cost-effective options. So I would encourage those who aren't sure to get some quotes before dismissing arbitration as an option. Divorce case law, so related but not directly a financial remedies decision, it was the case of Padero. It was an unremarkable decision, save for the helpful ground rules made by Mr. Justice Williams at the start of the hearing. So that's why I've included it in the handout, because I thought, on that paragraph 15, because I thought that some of these, particularly the latter ones, are helpful to maybe have as a checklist to take clients through before a remote final hearing happens. Clarify what's expected of them, clarify the mute, basic things, which I'm sure we're all doing already, but it's helpful to have that list. Penny and I were discussing it. We did think it was slightly surprising that one of the points on the list was a very emphatic no interruptions clause. But then, of course, we reminded ourselves that the husband in that case, both parties litigants in person in that case, and the husband had been said to be, quote, extremely rude to judges at hearings previously. So it was perhaps particularly necessary in that case that there were such strict ground rules before the remote final hearing commenced. Paragraph 16, I set out the new PD 36Q. The bit which I think is particularly worth mentioning out loud is PD 17A. For statements of truths, the new PD 17A amendment allows for an electronic signature. So that's interesting. I hadn't noted the reference for that, so it's helpful to have the explicit reference for that if the other side are worrying about it, or if a judge is worrying about it in a case. Paragraph 17, I attached the link to the Pump Court our website resource section. And I promise, I'm confident to say, I'm really not being biased in recommending it. It's a very helpful list. It's kept up to date with links to all the latest remote hearing resources. It's very easy to use, and I really do recommend it. It was of great help when adding to my own research of this topic before today's webinar. So now we come on to the general section. So we're off the financial remedies stuff, useful tips for remote hearings. And I'm going to rattle through it, but Penny and I are going to discuss them as a bit more of a conversation. So please do feel free to chip in on the chat function with any remarks you have. I'm just going to briefly look at it. I see that arbitration is being recommended.
We've got a good question from Andrew Bond, which we might want to talk about, and it will again be great to hear of all your experiences. The question is, do you find you need to remind judges of the various pieces of guidance, or are they across them already? Does it differ from DJ to CJ to higher up? My own experience is that we seem to all now be falling into an expectation that longer hearings will proceed by way of a hybrid arrangement, so that all the professional witnesses, including the social workers, obviously the experts, will all be remote. And the issue that's up for debate is really whether the parents should be in court or not. I'm yet to have a fully fledged argument about that, although I think I've got one coming down the tracks. There are one or two kind of interesting permutations. So, for example, the question of whether if a parent is to attend at court, but all other witnesses are going to be cross-examined remotely, is there going to be an argument to suggest it is unfair that I should go for the local authority to the court building and cross-examine from there? Now, it might seem a really obvious thing that one would want to be in the same room as the witness if that's possible to achieve, but I was met with not necessarily a fully formulated argument yet, but certainly an argument that that may not be a given, and that it may have to be scrutinised for fairness. And of course, Ray C tells us that the presence of an advocate or otherwise is, well, presence in the room certainly isn't required for a fair hearing. Whether one can insist on being in the room is perhaps a different question. But coming back to the question, my feeling is that they're a bit like us. We've been embattled with so many bits of guidance and so many ways of looking at the world and so much progress in the technology that we're all sort of fighting the same fight. I can't remember the last time a judge in court said to me anything that related directly to the guidance or cited it or pointed to a paragraph of it. As I say, the development seems to have been just this way of feeling towards hybrid hearings. And I think that's where it's worth remembering that these are still case management decisions. And if you have a strong feeling that actually your lay litigants would be better off at home and not in court, that's something you are going to need to articulate and argue for, because increasingly I think the drift is that parents will go to court and professionals won't. How about other people? Cordelia, what's your experience of this?
I was going to say, I think that you asking my experience ties in nicely to the question we also had from Claire Burton. With things being adjourned on flimsy excuses, sometimes without even reference to the party opposing the adjournment. I've had that happen a few times. I don't know about you, Penny, and it's been a case of, I think the more feisty I've been, the more I've got what I wanted, which I'm sorry to say, needs a bit of pushing sometimes. And a strongly worded letter to the court, drafted to set out, here's the guidance I'm quoting, here are the factors why this case individually is not suitable for a remote final hearing or is suitable for a remote final hearing. It's a bit of work, I confess. You know, in each case it takes a bit of time to tailor the factors from the guidance and the case law to the individual case. But that's the purpose of this handout, so hopefully it can make your job doing that a bit easier. And it works in the cases where I've had opposition to a remote final hearing from my client, and I've drafted something accordingly. We've sent it into the court to say, no, even in one case where the court already made a decision, and we said, no, but you haven't received submissions on it, here are the submissions on it. It's not appropriate to be heard remotely for these reasons. The court's changed their mind. So my main response to that question is don't be shy in going back to the court, even when it either appears or is confirmed that they have actually made a decision without really looking at the situation properly. I've had another case where the judge listed a hearing to decide whether or not the next hearing, there was an FDR in that case, should be dealt with remotely. So it's which was a surprise for an FDR, but there we go. So don't be shy is my main advice. Don't necessarily. I'm cautious of saying that as strict advice, Penny, in case you disagree. But
no, not at all, not at all. We've had some interesting comments on our chat string. Tanya Bloomfield saying to us that in her local court, and I'm not sure where that is, I'm sorry, Tanya, you're being asked to file position statements in advance of hearings to set out individual parties' views on remote, hybrid or attended hearings. So that seems to be as though it should be a standard direction in all our courts. That's in Middlesbrough, York and Durham. So that's a hello to Deer Street up there from me. But anyway, moving swiftly back, that seems to me like it should be a pretty standard protocol for all our courts, because you know, let's face it, these are still really important case management decisions, and I'm finding that quite a few of my cases are being shipped off to final hearing in, I don't know, October, November, December, without the issue being addressed. Just being put into the diary. Now, of course, we all know that lockdown may have significantly eased by then, life may be back to normal. So it might be sensible not to address the manner of the hearing at this juncture. But I'm thinking we ought to have a case management appointment in the diary for a month ahead of a hearing in order to look at how it's to be conducted in the light of the restrictions that are then in place. And meanwhile, make sure we plan for professional evidence to be dealt with remotely, because otherwise it may be too late to line up your witnesses. So that I hope we'll get to the point where that's a standard part of proceeding towards final hearing. Geraldine Watson saying she has received a questionnaire to help the court decide if the hearing can go ahead or not. So that's a great place in which to do as Cordelia has suggested, and set out your stall, make your pitch for what you want for your client. And Sean Williams just saying that she's had a 2-day fact find listed for the 1st and 2nd of February of 2021 because it's not suitable for remote hearing. That's terrifying, isn't it? That's the last direction on the 6th of April. It might be, given all we've talked about and the way in which matters have proceeded, worth issuing a C2 and have that one called in, have a CMH or a directions appointment, and see if that decision could be revisited, if it's capable of being revisited in a way that's fair, because that's an incredibly alarming delay. So yes, I mean, the other factor that comes to light in the middle of this chat is how different courts are handling things differently. There seems to be no particular standard way in which different courts are approaching these questions. And again, I think that chimes in with what we were talking about earlier, about judges feeling they have to manage the best they can without necessarily knowing what that ought to look like necessarily in light of the guidance. But there are a few tips that we thought, or pointers or points of experience that we thought were worth just mentioning. We all know, I think, that remote hearings are going to take longer. And despite the pressure we're all under to case manage within an inch of our lives, we are still going to have to remind our judges that lay parties can't be expected to sit through evidence in their front room from 10 o'clock till 10:30, 10 o'clock till 4 or 4:30 without breaks. We need to build in breaks for instruction taking, and I think importantly, witness feedback. You'll all know, we all at court, when we have a little break, tell our lay clients what we thought of the witnesses and explain to them how we felt the witnesses came across. Routinely, I would do that if there were a morning break and at lunch break. And we have to have time to do those and not necessarily to have to cluster them all into a conference at some remote point. And I think judges need to be reminded to build in time for that. I think many of us by now will have realised that it's a really valuable thing to be able to have two strings of communication going. One is obviously your remote platform for hearing, so that is likely increasingly to be the CVP, but the other might be either a WhatsApp string or even a Zoom call on a different screen, where you are able then to take instructions, keep in touch with your client. And also a point which I hadn't thought of, but that somebody else made to me. Your client may find it really reassuring to be able to see you as you conduct the case without distraction, to have a point of focus on you. After all, they repose huge confidence in us, and we want to generate that feeling that we are really looking after them. And I think that could be quite a useful point to follow up. I've had, I suspect others will as well, but I've had real issues about privacy, and that's a huge worry. I've had at least one conference where I am almost wholly of the view that there was another person in the room, and I think, unfortunately, in a case which is likely to be a cutthroat, will develop that way, that other person was the other parent, who may have caused the harm that we are unravelling to the child. Now, that is a huge worry when we're having to proceed with conferences and take instructions remotely. I don't have any great workaround, save to say that matters are easing in the sense that more of our solicitors' offices are open. And I think for us at the bar, it's important to think about whether we insist cons should happen on that basis, if at all possible. It's less easy to do it in the course of a hearing where you have two parties in the same room as each other, listening to the evidence, and even more worryingly, where there may be children of the family in the background. One of the suggested tips from the Family Justice Observatory's part 6 of their report was to ask lay parties to conduct a camera sweep. So literally to move the camera around so that you can check whether there's anybody else in the room. It's not fail-safe, but it might help, and it would certainly unnerve anyone who thought they were able to sneak another person in or simply not mention that another person was in the room. So that I thought was probably worth thinking about. But I think foremost for me is how we tackle the business of how our lay clients participate. Now, if you look closely at the guidance, you'll see that according to the President, it's as much the court's duty to facilitate participation, to ensure that a lay party is able to access the court properly. Quite right too, because that's part of the party's Article 6 rights. And as a public authority, the court is under a duty to ensure that steps are taken to respect that right. However, in practice, I haven't yet come across a judge who has been anxious to establish how we're going to go about hooking in our clients. And perhaps all of us are now coming to the point where we're thinking about whether local authorities can provide a laptop. I certainly know of local authorities buying lay clients dongles for their mobile phones. It's a situation of trying to reach out for practical help to try to ensure that lay clients can validly participate, whatever the drawbacks. And I think that requires lots of focus in advance. That and making sure that the court allows a possibility of a trial run on CVP for lay parties, not just lawyers, and for us all to ensure that our clients make use of those. I have found, I think, that very few of the lay clients in cases of mine have been able to join CVP on video link. The majority appear to have to resort to only phoning in. Whilst that's fine for most CMHs, it's not going to be fine when it comes to hybrid final hearings. And I think we're all going to have to join in an effort to make sure that steps are taken, that CVP is made familiar, and that time is set aside in the court diary so that we can do trial runs and support our clients accordingly. So I've just talked at you now for about 5 minutes. Cordelia, I wonder what you have to add.
I had a few points to add before we finish. The first is there's been some questions in the chat about PDF bundles.
Yes.
Hopefully I was about to come on to that. It's at paragraph 22 of the note, and I've sent out the link which appears in the note. It's the link to the PDF document produced by the President recently, end of May. And I've also produced a link which appears in that PDF document, which is St Philip's Chambers have produced quite a helpful video. So any solicitors who haven't got to grips with PDF bundles, they are tricky, have a look at that video, and hopefully that's a useful guide to producing them, particularly when they're unfamiliar. Like many of these things, I'm sure it's once you've done one or two, you're well on your way, but doing the first one or two is no doubt a more time-intensive exercise.
So just to chip in there, the key points to tell you about PDF bundles is, one, they must be put through OCR software, which is optical character recognition software. Now, lots of people aren't doing that, but it is a requirement of that guidance. And you need something like Adobe DC, I'm sorry, to be able to do that. PDF Expert won't do that, or at least it wouldn't in its last iteration. The other point made in the guidance is that it must be a hyperlinked bundle. So you've got to have a means to make your index hyperlinkable. Personally, I don't know how to do that. It's something I'm going to have to learn. And finally, in response to your point, no, I'm not aware of the courts using Dropbox or any other kind of cloud storage or communication facility. It'd be interesting to hear if others have had any experience of that. In my experience, we're still having to send in chunky bundles by email, and we haven't achieved anything better than that yet.
Richard Stanley was asking the question, are there companies that can prepare bundles, e-bundles? I'm not familiar with companies, but I'm familiar with software. A couple of my instructing solicitors use software to produce e-bundles. I'm afraid I don't know whether Sean,
yeah, got some good advice here.
Much more helpful recommendation because
yeah. Marcia, I don't know if the court realise OCR makes the bundle much larger. The bundle that was being complained about in the case I happened to do a couple of weeks ago is something like 5,000 pages, and the poor local authority is going to have to OCR the whole lot, which is pretty alarming. I mean, the file sizes are ludicrous, and the time it takes to do it personally is bonkers. You might as well leave your laptop running overnight. But nonetheless, I think we're going to find judges want it to happen. We're going to have to find a way of doing it. Thanks also for the bundle docs recommendation. That is a brilliant recommendation. Xylpha is being recommended now. £50 per bundle is amazing value. There are remote PAs who are offering this service too. I suspect at greater cost though. It can be done, it can be outsourced. You just have to make sure, like all these things, that the outfit you go to, if you're handing over documents, is fully GDPR compliant, and that you've satisfied yourself that they have a robust policy and aren't going to muck it about or drop your data anywhere. Yeah, more chat about the practicalities. Mimecast not accepted by the court. Can't believe the judge wouldn't take a bundle that was more than 50 pages, by the way. That's fairly alarming. But what this chat is telling us that these are the issues that you're having to grapple with to try to get your kit in order. Never mind the business of sorting out the platform and the technology. Just the sheer logistics of getting the papers in front of the judge. So I'm delighted that we have had an opportunity for that chat to take place. Thank you all for it. So I think our time has run out. It would be lovely to hear from any of you with any feedback. It would be also great if you have any questions for us or just points you want to bounce off us. There are lots of dilemmas still to unravel about how to conduct hearings. I think the main issue is just to remember hybrids are not a given. We should still be questioning the best way for it to proceed. And thank you all for attending. The President said in his road ahead something about the road being long, and he, I think, picked his little ditty from a song that we probably all know, which he points out has the line in it that the road may be long, but we'll get there. But what he hasn't mentioned, I'm afraid, is that the lines of the song also include the phrase that the road leads to who knows where. I have to say, I'm not sure where we're all going, but we hope that this conversation will have helped you to frame your points of reference as we move ahead. Thanks so much for attending, and we're really grateful. I hope we'll see you again.
Thank you, everybody.